My name is Kristen Miller. Thanks so much for having me. I'm one of the attorneys at Democracy Forward, which is a nonprofit litigation firm that brings public interest lawsuits on behalf of other nonprofit organizations like California Tribal Families Coalition. And I'm here today to talk to you about one of those lawsuits called the AFCARS lawsuit. We refer to it as AFCARS because we sued on behalf of CTFC and 6 other plaintiffs. We sued the US Department of Health and Human Services over their administration of AFCARS, which is a national database that collects data on foster youth and other children in the child welfare system, as well as data on their families, their adoptive families and their foster families, and other aspects of their experience in the system. So we sued HHS to ensure that they would collect 2 kinds of data. The first is data on the implementation of ICWA, specifically whether and how well ICWA is implemented for American Indian children in the foster care system. The second type of data that we want HHS to collect is data on the sexual orientation of youths aged 14 and older, as well as the sexual orientation of their foster and adoptive families. Foster and adoptive parents. So why does this matter? Collecting data sounds kind of boring and pretty abstract, but it's actually critical to enable the government and other stakeholders to improve outcomes for both American Indian children and LGBTQ children. And if we could go to the next slide. So to put this into context, I provided here a graph that shows some statistics that folks may already be familiar with. American Indian children and LGBTQ children are vastly overrepresented in the child welfare system, and they enter the foster care system at a rate that's at least 2 times their proportion in the general population. They also tend to experience disproportionately negative outcomes in the child welfare system, both while they're in the system and afterwards. So for example, American Indian kids are often removed to non-tribal families and placed in non-tribal families. And when that happens, they are more likely to report a variety of mental health issues than their white peers, including, for example, alcohol addiction, alcohol and drug recovery, eating disorders, self-harm, and suicidal ideation. So this is obviously not good. And as folks here are well aware, Congress passed a statute in 1978 to address this problem in part through the Indian Child Welfare Act. Apologies for the misspelling on the slide there. So ICWA addressed this problem by providing a number of protections that are designed to ensure that children are not removed from their families or their tribal communities. So for example, as folks here are well aware, state child welfare agencies have to provide notice to tribes and families whenever they start proceedings to terminate parental rights or to place a child in a foster care placement. But unfortunately, ICWA has not been implemented well, even though it was enacted over 40 years ago. So what can we do to address this problem? Part of what we can do is to collect data and to try to understand why it is that ICWA isn't being implemented well, and why it is that American Indian and LGBTQ children show up in the system at a higher rate than their peers and experience worse outcomes. And if we could go to the next slide. So in 2016, the HHS under the Obama administration tried to address this problem in part by collecting data through AFCARS, which, as I mentioned before, is a national database that collects data on children in the child welfare system. To give a bit of background on AFCARS, AFCARS was created by Congress under the Social Security Act, and it requires HHS to collect this data from state child welfare agencies, who are in turn required to report the data in exchange for federal funds. So in 2016, HHS decided to collect data on that tracks ICWA's implementation. So for example, just as state child welfare agencies are required to provide notice to tribes and families under ICWA, under AFCARS, under the 2016 AFCARS rule, they were required to report to HHS whether or not they provided that notice and whether or not they provided it on time. HHS explained when they implemented the 2016 rule, when they promulgated the 2016 rule, that collecting this data would be immensely valuable for improving outcomes for Indian American children and also for LGBTQ children. But they also recognized that collecting the data would cost a lot of money, that it would, require time for state child welfare agencies to train their staff and to update their systems to be able to collect the data. So they gave states a lengthy timeline to implement the required changes, and states did not have to report this data until 2019. And they also offered to provide technical assistance. So let's go to the next slide. Unfortunately, when the Trump administration came into power, they immediately set about trying to undo the 2016 rule. And they did that in two ways. First, they relatively quickly put out a new rulemaking that delayed the deadline for collecting this data for the first time until 2020. That gave them time to then do a new rulemaking that rolled back the data collection requirements. So basically, they eliminated a whole bunch of new data requirements that were in the 2016 rule, including 18 of the 24 ICWA data elements, as well as all of the sexual orientation data elements for youth and foster adoptive parents. Their primary rationale for doing this was that collecting the data was, in their view, too costly. And they concluded that the costs outweighed the benefits, which was the exact opposite conclusion that HHS came to in 2016. They also delayed the implementation of the data collection even further to 2022. So for the new data elements that they retained, states don't have to collect those until 2022. So we can go to the next slide. So we decided to sue them. And we put together a coalition of 7 plaintiffs headed up by CTFC, as well as 2 tribes, including the Yurok tribe here in California and Cherokee Nation, a group that is a membership organization for foster care youth and alumni called Facing Foster Care in Alaska, and 3 LGBTQ advocacy organizations, including the Ruth Ellis Center, True Colors United, and Arc of Freedom Alliance. As for the council, Democracy Forward has co-counseled with Lambda Legal and Catherine Fort, who is a professor at MSU and an expert in ICWA. We can go to the next slide. So we brought numerous claims under a statute called the Administrative Procedure Act, or the APA. For those of you who don't know, the APA requires agencies to adhere to certain requirements when they promulgate rules and regulations. Among those requirements include a comment period. They have to propose a rule and provide the public notice of the proposed rule and provide the public with an opportunity to comment on that rule. Then when they finalize their rule, they have to provide a reasoned explanation for their action. And that reasoned explanation basically has to withstand like the sniff test. It can't be internally inconsistent. It can't be contrary to the evidence before the agency. It can't be outside the agency's statutory authority. So basically, judges will review rules to make sure that the agencies have said something that makes sense to rationalize their decision. If the judge finds that the agency's reasoning is insufficient, then the rulemaking will be deemed arbitrary and capricious, and the judge can set the rule aside. So we argued that the Trump era rollback of data elements violated the APA for a whole bunch of reasons, and I'll just provide one so that we don't go over time. So the Trump, as I said before, the Trump HHS rationale for rolling back the rulemaking or rolling back the data collection requirements was that the data cost too much, that the cost of the data outweighed the benefits of collecting that data. And we made a bunch of arguments saying that their cost benefit analysis was seriously flawed. For the biggest problem with their cost benefit analysis was that they'd never considered the benefits. So they said, oh my gosh, this data is going to cost so much money to collect, but they never looked to the benefits to actually see whether or not the costs outweigh the benefits. And because they didn't do that, their conclusion that the costs outweigh the benefits is arbitrary and capricious and wholly unreasoned. So that's just one example of many, many, many flaws in the agency's reasoning in this rule. So we can go to the next slide. So I'll quickly go over the timeline of the litigation and then talk about possible outcomes and next steps. So we filed our complaint in August of 2020, which was a little under a year ago. The defendants filed an answer in December. And then because there was a transition between administrations and because the new administration wanted to settle the case and come to some kind of amenable resolution, there were a number of extensions on the briefing schedule, the schedule on which we submit our briefs to the court. We ended up submitting our first brief last month, followed closely by a number of amicus briefs from parties who submitted briefs supporting our position, including a brief from Congress, which was signed onto by a number of notable Congress people and senators, such as Senator Warren and Senator Brown. And currently, we just received another settlement offer from defendants, and so we have extended the briefing schedule again, and defendants are due to submit their responsive brief in July. So we can go to the next slide. So here's what could possibly happen. First, we could settle over the next few months. And because we would not settle unless we got a favorable outcome, if we're able to settle, that would be a good thing. I can't go further into the details of that because that's confidential. But if we are not able to settle, there is some possibility that defendants would move for voluntary remand without vacatur. So what that means is that they would ask the court to send the rule back to the agency for the agency to reconsider it while they do a new rulemaking. In the meantime, the court would not vacate the rule. So the 2020 rule would remain in effect, and state agencies would not have to report this ICWA data or sexual orientation data in the interim. This would not be the best outcome because we, the plaintiffs, wouldn't have any leverage over the timing of the new rulemaking or the content of the new rulemaking. However, under this administration, a new rulemaking would likely reinstate the ICWA data elements and the sexual orientation data elements given this administration's values and position. If the defendants do not move for voluntary remand without vacatur, or if they were not successful in that motion, then the parties would continue to litigate the case, and we would seek a ruling from the court. And because of the timing of that, we likely wouldn't get a decision until late this year or sometime next year. And at that point in time, there are two possible outcomes. One, if we win, we would ask that the court vacate the 2020 rule in its entirety, which means that the court would set the rule aside. We would go back to the 2016 rule, which required state agencies to collect the sexual orientation and ICWA data. That would be a good thing. If we lose, we lose, but hopefully that doesn't happen. So in any of these scenarios, HHS will likely conduct another rulemaking. And if that happens, we would encourage everyone here to please submit comments urging the agency to reinstate the ICWA data elements and the sexual orientation data elements, which are so critical to improving outcomes for these kids. And I'm happy to take any questions later. Oh, sorry. And here, one last thing. This slide has some sites on it if you're interested in finding either of the rules at issue or the relevant statute.